call for sensibility as it relates to the scourge of crime. I can tell you that whilst we manage the COVID pandemic, and whilst we try our very best to save lives, that crime and gun-related crimes in particular still continue in our country. You can look to the statistics for murder. You can look to firearms offences. You can look to arrests for firearms. And the Commissioner of Police came into the public domain yesterday and informed our country that Trinidad and Tobago has with certainty witnessed thousands of persons arrested for firearm offences. I can tell you that my own look at the statistics in Trinidad and Tobago demonstrates that for a 10-year period, 2009 to 2019, firearm charges number in total, not including the year 2020, for the period 2009 to 2019, 6,387 persons charged with firearms in their possession. I looked to the report of firearm-related offences for the same 10-year period, 2009 to 2019, 17,271 firearm-related offences. Those are reports. So of 17,000 odd reports of firearm offences, there have been 6,387 charges. If you look at arrests for possession of firearm, again in the 10-year period, 2009 to 2019, you're looking at arrests standing at 5,391. When we look to arrests under the Anti-Gang Act, again in the period 2009 to 2019, we're looking at a number of 213 people arrested under the Anti-Gang Act. As you're well aware, 5 in 2019 alone, 16 in 2015 alone. So we've had a significant number if you take out the 177 in the state of emergency, and I'll come to that in a moment. When we look to the reports of gang-related murders for the period 2015 to 2019, the number stands across the divisions, gang-related murders, 638. When we look to gang-related murders apart from firearm-related murders, for the period 2015 to 2019, we have had murders with firearms, 1,679. Now, those are staggering statistics. Those statistics tell us that 17,000 reports of firearms used in crimes have come up. We are seeing the Commissioner of Police tell this country that 5,000, 6,000 people are being arrested for firearm possession. The Commissioner of Police has told this country that that equals on average to about 2 persons arrested every day for firearm offences. The Commissioner of Police has come into the public domain and said that Trinidad and Tobago has witnessed a very significant occurrence of a frequent access to bail. Now, I would like to remind the population that the bail legislation in this country was born in the year 1994. In the period 1994 to 2015, we had many amendments to the Bail Act, but in particular, on 5 occasions in the period 2011 to 2015, we amended the Bail Act. And the amendments to the Bail Act allowed for no bail for 120 days. Let me repeat that. No bail for 120 days for firearm possession and if a firearm was used in the course of the commission of an offense. That bail restriction was absolute. Section 5 of the Bail Act was amended by the Parliament, was amended by Mrs. Kamla Persad-Bissessar as the Prime Minister of this country, Senior Counsel, on 5 occasions to give a denial of bail for up to 120 days. You did not have the right to access bail because the law, as it was drafted, specifically said you cannot approach the court for bail. As you're well aware, there was a sunset period applied to that law, and the sunset period expired in June 2016. Those were the amendments to the Anti-Gang and Bail Act. In June 2016, as Attorney General, I went to the public, I went to the Parliament, I asked for a 2-year extension of time for that law, and the UNC refused to support the law. The law, therefore, cascaded back to 1994, and the firearm offences, you could not be looked at for a bail application only if you had 3 convictions. 3 convictions. So in the period 2011 to 2015, Mrs. Persad-Bissessar oversaw a government that amended the Bail Act so that if you had a firearm in your possession, if you had ammunition in your possession, the 2015 amendment said if you had that in your possession or whilst an offense was being committed, you will not be able to knock on the door of a court for up to 120 days minimum to apply for bail. I want to remind this country, in amplifying what the Commissioner of Police has done in a most exceptional way, that we took note of a few matters appearing in today's papers, and in particular allow me to refer to the position where it's reported in today's Guardian, Tuesday, May 19th, 2020, 3 charged for high-powered guns, ammo, drugs, get bail. Persons were brought before the court and granted bail, 3 firearms including 2 high-powered rifles and a large quantity of drugs and ammunition. I also took note of a report in today's Newsday. And in today's Newsday, the title is Kamla, Bill Can Be Politically Weaponized. The leader of the opposition is saying that the opposition felt that they would not support the bail amendments that the government brought recently. Last week, at a sitting on Friday, we went to the committee stage of amending the Bail Act. We were seeking to amend the Bail Act because we had already gone to the Senate, and the independent senators, together with the government bench, agreed to amend the Bail Act so that if somebody was found in possession of an automatic weapon, a grenade, a weapon of war, described as a prohibited weapon, because we described and said what a prohibited weapon was, or if you were charged with trafficking in firearms. In those 2 circumstances, we asked for the person who wants bail to go to the court and ask the court why they should be considered in an exceptional circumstance to be granted bail. In other words, we did not go as far as the UNC did in their 5 years in government, where you had no bail whatsoever for 120 days for a firearm matter under the laws that they had in those arrangements. We went and we said, pursuant to amendments we made last year on the Bail Act, we said, if you are charged with trafficking in firearms, or if you have weapons of war, what the Commissioner of Police referred to as cop killers, 1 bullet that could pass through 5 people and kill all 5 at the same time, in those circumstances, you must ask the court to consider bail in what you say is exceptional circumstance. Mrs. Persad-Bissessar is quoted in the Newsday as saying that this is too much in violation of citizens' rights. She said that there were no checks and balances. She said this is where you can get held without bail, just thrown in jail. She said the opposition proposed that that restriction should only come if you are a third-time offender. In other words then, you must be caught with a firearm or have shot somebody with a firearm or have a firearm-related offense 3 times before Mrs. Prasad Bisesa says you should be granted no bail. Let me put this on record. The Hansard coming from the United National Congress, when they were in government, I took the opportunity to pull so that I could describe to you from the words of Mrs. Prasad Bisesa's government, the UNC government, what the position on firearm-related offenses are and bail. And I want to point this out to you. In Act number 11 of 2011, the Attorney General Anand Ramlogan said that there is just cause in this country to interfere with fundamental human rights of those who wish to interfere and take away altogether the fundamental human rights of law-abiding citizens. We cannot, as a society, countenance any more being held to ransom by a minority in this country. He said, we think that denying bail to gang members and persons charged with offenses involving the use of a firearm ultimately strikes the right balance between the right of the individual and the right of the defendant. He went on to say, there is no absolute or divine right to bail in this country. He went on to say, one cannot be sympathetic in dealing with criminals. He said, we won an election based on our promise to deal with crime, and we have to deal with crime. He said, Trinidad cannot be sympathetic. In 2014, again, Ramlogan said, the criminal minority was allowed to take a hold of communities. He said the legislation is targeted. He said the government is prepared to take tough measures, specifically saying this government is not about to do like the previous administration and bury its head in the sand. We confront the raw and harsh criminal reality, and we confront it through tough legislative measure. He said, one strike provision is the targeted way. He said, enough is enough. No bail in such a case. One strike and you are out. Again, he said there's no right, an absolute right to bail. He said the time is now for legislation such as this. He says this legislation is not an affront to the separation of powers. And so they go. Gavin Nicholas, as Attorney General, said in 2015 in piloting the amendments there which passed, firearm offenses are for more severe measures. We feel that the government needs to send a strong warning to members in society. March 13th, 2015. The records of this country demonstrate, from the Hansard excerpts I've just read to you, that the UNC's position was that one strike is all that matters. No bail for 120 days for firearm offenses. We came to the country last year and amended the Bail Act to say that you always have the right to ask the court for bail. Always. We included a new section, Section 5, subsection 7A, that said, notwithstanding the law, a person can go before the court and show why, in exceptional circumstances, they should be granted bail. Why did we do that? I just read to you amendments to the law coming from the UNC in 2011 and 2012, 14 and 15. Act number 9 of 2011. Act number 11 of 2011, Act number 12 of 2012, Act number 1 of 2014, Act number 7 of 2015. Would you believe that the reason that that law was recast came about because Mr. Anand Ramlogan went to the court brought a claim against the very law that the UNC had passed in 2015, asking for the law in its part that he challenged to be struck down as being unconstitutional. So not only did Mrs. Prasad Bisesa take the bail amendment so that you have no right to ask the court for bail for up to 120 days for firearm matters, not only did she take the law that if you were found with a sidearm or if you had a bullet in your possession in the course of committing a crime, etc., that you would fall within the treatment for the 120 days no bail, but her own Attorney General, after he was dismissed or supposedly resigned, went to the court to challenge the very law that his government had passed. I want to say something further. I took note, as I told you, of Mrs. Prasad Bisesa saying, first of all, no checks and balances. I want to tell Trinidad and Tobago that the checks and balances are there in Section 5, subsection 7A, where you will always have the right to knock on the door, reversing the burden. You must now show the court why in exceptional circumstances you should get bail. Where does that come from? The United Kingdom and Canada. They have similar laws. Secondly, for Mrs. Prasad Bisesa to say that it's only when you are a third-time offender that you should not get bail, I want this country to pay attention to what Commissioner Griffith said. And I would like our country to pay attention as well to the newspaper report that I referred you to, where 3 people were granted bail whilst they're in possession of high-powered weapons of war. I want you to pay attention to the shooting spree in December last year, where 1 automatic weapon killed people at downtown Port of Spain and shot people in their tens of numbers. I also want you to pay attention to Mrs. Prasad Bisesa saying that this bill will effectively allow the Trinidad and Tobago Police Service to be manipulated by a government. And I would like to ask Mrs. Prasad Bisesa here today, on behalf of all of the citizens of this country, if the Honourable Leader of the Opposition can explain where was the concern for set up by police in the tenure that she occupied as Prime Minister, when Mrs. Prasad Bisesa says, and I quote from the article appearing in the Newsday under Paul Lindo's byline, she says, the bail package needs serious reform as it goes against poor black people. The quotation goes as well, the system militates against poor black people especially. I would like to ask Mrs. Prasad Bisesa today, where was the concern for poor black people when the state of emergency was declared on August 21st, 2011, when it lasted for 3 months until the 4th of December 2011, when 7,000 people were arrested under the state of emergency, when 463 people were arrested supposedly for breaches against the Anti-Gang Act and bail amendments, where 213 people were released by the DPP because there was no evidence, where 142 people were charged under the state of emergency under the Anti-Gang Act, where 33 people found themselves under the Anti-Gang Act in the Magistrates' Court, where 40 people found themselves under the Anti-Gang Act in the High Court, where the state witnessed no assistance from Mrs. Prasad Bisesa and Mr. Ram Logan when I, as Attorney General, wrote to them through my attorneys, asking them to give evidence in the claims that came against the state, and neither of them were willing to give evidence to save the claims for damages and costs that came, that have crossed into the millions of dollars. I would like to ask Mrs. Prasad Bisesa, where was she in her concern for poor black people and for the purse of the taxpayers in the anti-gang claims, the malicious prosecution claims, the false imprisonment claims. And I would like to ask Mrs. Prasad-Bissessar, why, as the head of the National Security Council, she did not give evidence to the state, to this Attorney General, when we wrote to her to ask her to give the reasons to the court so that the taxpayers can be spared spending millions of dollars in damages and many millions of dollars in legal fees. For the record, the statistics of Trinidad and Tobago demonstrate that our poor black people, as Mrs. Prasad refers to us, are approximately 50% in the jails. So I don't know where Mrs. Prasad-Bissessar gets her figures from. Nor do I accept the argument that this law that is intended for the benefit of this country is targeted against poor black people. I would like to say that the statistics that I've read for you from the period 2009 to 2019 would show you more than 17,000 firearm matters in this country, would show you hundreds of murders in gang-related contexts by the use of a firearm. That those firearms, when compared to the Commissioner of Police saying that we're arresting 2 people a day, and we have a continuation of violence whilst we deal with COVID, people continue to be murdered by the use of firearms. And I would like to ask this country to stand up against this form of callous disregard for the benefit of Trinidad and Tobago's citizens. How can Mrs. Prasad-Bissessar watch the Hansard debate, say that it is okay to deny bail absolutely for 120 days, 2011, 2012, 2013, 2014, 2015, but it is not okay to say show cause why you should get bail in exceptional circumstances? How could it be okay for Mrs. Prasad-Bissessar to say to this country, you could only get restrictions on bail when you have had 3 strikes? The statistics show us from the Commissioner of Police's own mouth that the number of reoffenders demonstrate that people who have been charged for firearm possession and who are released on bail more than likely have committed the very murders that we are looking at. In the COVID pandemic and in our focus upon our economy and more importantly our lives, this conversation on the bail amendment and the UNC's allowing it to fail may have been lost upon the citizens of this country. It is not every day that a commissioner of police steps out to say what a commissioner of police said yesterday. And I want to remind you who the commissioner of police is. The commissioner of police served firstly as the National Security Advisor to Mrs. Kamla Prasad-Bissessar. The commissioner of police then served as the Minister of National Security under Mrs. Prasad-Bissessar. The commissioner of police was in the parliament himself when we did some of these amendments. The commissioner of police has come to the country and said that there is no excuse available to the citizens of this country from Mrs. Prasad-Bissessar saying she will not support the bail amendments. We are in the fight of our lives. We are dealing with a COVID pandemic that has killed thousands of people around the world, killed people here in Trinidad and Tobago. We are, for the first time in this country, looking at a situation where the entire world has been shut down at one time. Never before in the history of our world have we had a shutdown from the Far East to the West at the same time. But whilst that shutdown is going on, in Trinidad and Tobago, murders are happening with firearms. We have demonstrated that weapons of war, automatic firearms, grenades, missiles are found in our country, and the police are doing their part to arrest these people and bring them before the courts. And the only thing that any politician can do who has a seat in Parliament is to pass laws. And the law that has been brought, which is to amend the Bail Act, to say if you have found yourself before the court for trafficking in firearms, or if you find yourself before the court with a weapon of war, a prohibited weapon, a grenade, a machine gun, a missile, that you should ask the court in exceptional circumstances to get bail. Trinidad and Tobago cannot afford to go to bed on this issue. Why? When we saw the collapse of the bail amendment law, when the UNC refused to support the law, when Mrs. Prasad Bisesa refused to support the law, it was the public outcry that allowed that law to come back to Parliament. When Mrs. Prasad Bisesa refused to support the FATCA amendments to introduce declaring foreign bank accounts, which the UNC was dead set against, which Mrs. Prasad Bisesa said she would not support, it was the public outcry that allowed that law to come back to Parliament. When Mrs. Prasad Bisesa refused to support the income tax amendments, it was the public outcry that brought that back to court. The only way that the population will achieve its protection is if there is a public outcry. I'm very conscious that this message may have been lost in the COVID pandemic, but I cannot, as a responsible Attorney General, witness a Commissioner of Police step out in the way that he has, coming from the position of being the Minister of National Security under a UNC government, who can speak firsthand to what they had by way of tools in the arsenal against the fight of crime, against crime. I cannot witness that and not come to the public to bring this matter to its attention. Can I tell you, ladies and gentlemen, that this is something by way of balance? I want to remind you that our courts are still sitting. I want to let you know today that in the period of the COVID pandemic, March 16th to May 13th, 2020, as a result of this government doing what it needed to do and the judiciary doing what it needed to do, we have had over 5,832 matters held in court, in particular involving 3,526 virtual hearings, in particular involving over 1,450 matters from the prisons being done by virtual hearings. In other words then, the access to the court that we allow somebody who has to show reason why they should get bail is happening from our prisons as we speak, thanks to the opening of 12 video conferencing facilities in the courts. The law is proportional. The access to the court is guaranteed by Section 57A. I ask Trinidad and Tobago, through you members of the media, to pay attention to this issue and demand the return of the bail amendment bill into the Parliament. It has already been passed in the Senate. The UNC defeated it on Friday, but there is still a chance for that law to come back only if the leader of the opposition reverses the inconsistent and ridiculous position that she has taken to say that the law must only be there if you have 3 strikes. It is against the record. It flies in the face of the law that she brought via her government in the period 2011 to 2015, and I'm asking the members of the media to allow the citizens of Trinidad and Tobago to find a voice on this issue. May I invite your questions at this point?
Yeah, you spoke about the bail amendments that were done under the UNC between 2011 and 2015. And you said they essentially seeking to strengthen them and bring them back. The fact remains, though, that the crime rate didn't really change that much between the period 2011 to now. So how sure are you that this is going to be so effective as you are touting?
Well, that's in fact, when you look to the statistic of murder, I'm sure you're well aware that the UNC is constantly saying that the murder count was less under its tenure. If we look to murder, and we look to murder by firearms, one of the reasons attributable to the murder count being better managed is because the bail amendments allowed nobody with a firearm matter to be outside in 120 days. So the evidence is to be found in the statistics themselves. So if you listen to what the UNC tells the country, statistically, firearm offenses were less under the management of bail laws in the period 2011 to 2015. So the data demonstrates that the bail amendments are required. What this government has been fighting, even though we are now taking cases forward with rapidity, even though we're now doing judge-only matters, even though we have matters being dealt with in 15 minutes flat, even though we have virtual hearings, we are denied the ability to put persons into the jails on remand for 120 days. And that is why the law is required. I believe it to be the truth that the UNC believes that if more people die in this country by not having a law which restricts bail, that they will prosper. But you cannot understand their logic or lack of logic, because in the period 2011 to 2015, you could not get bail for 120 days minimum if you had a firearm matter. It's not the case since 2016, 17, 18, 19, and 20 under this government.
Chancellor Van Newsday, good day, AG. Did the PNM support the bail amendments that were made under the UNC's tenure?
Yes, we did.
Fully?
Yes, we did.
And you don't expect that, well, politics is at play here. Do you think that the public outcry will bring the UNC back to the table?
It brought us back for the anti-gang passage. It brought us for FATCA. It brought us for Global Forum. It brought us for so many things. The public outcry, when we said no to child marriage, compelled the UNC. They voted it down in the Senate, and they were compelled to say yes in the House. You see, the public outcry matters. And just to address a small point, we in the PNM have never played politics with crime-fighting tools. I want to remind you, the Children's Act in 2012 was only passed in the Senate because of the opposition PNM voting with the UNC government. Every single independent senator said no to the Children's Act because they wanted child marriage abolished at the same time, and they wanted same-sex marriage treated with at the same time.
Now, you make a mention of having no bail. There's an overpopulation in the prisons. How do you marry the two? You want to deny bail and at the same time deal with overpopulation?
Very good question. We want to deny bail for firearm matters and weapons of war. You are very well aware that as Attorney General, I have at the same time done three things. Number one, we saw the passage of the electronic monitoring legislation, its regulations, and its go live momentarily. Number two, as Attorney General, I took two novel matters to court. The first one in December 2019, and the second one very recently, where we have sought to take people out of jail by the hundreds for small matters that they respectfully ought not to be there. We already crossed 121 people in the most recent matter being released by the Commissioner of Prisons. We are before the court with the Chief Public Defender right now on over 30 matters of bail applications. We met with the DPP up to yesterday as a team looking at persons who have charges, who are in custody on remand, where the DPP will look at exercising, if he considers it, his nollie prosecution capacity, where he will discontinue matters. So we are not saying fill the jails. We are doing our part to decant the jails, to take out marijuana-related offenses, traffic offenses, maintenance matters, non-violent matters by the hundreds. What we are saying is fill the jails with people that have automatic firearms and grenades and weapons of war.
No, I don't know if my colleagues have any questions pertaining to this. I want to just branch off into the pandemic release of inmates. So,
sure.
Yeah, you made mention of it just now there. What's the latest with that? Both the pandemic release and the marijuana release? Because we have seen that the Mercy Committee needs to meet, and they are over, the last thing I feel, over 500. I can't remember the exact number. How soon will we be seeing the release of prisoners?
So I can update you right now. Yesterday, we did a full conference, DPP's office, Public Defender's office, the Prisons Authority, the Attorney General's office, and we sat down with the Commissioner of Police's team as well. We went through all of the data that is being brought forward. Right now, we're just awaiting one final piece of the puzzle, which is the bail officer's file for the applications that are before the court right now. And for the Mercy Committee, from the prisons, we're looking for the welfare officer's report. As we receive the welfare officer's report, the Mercy Committee will start its deliberations. And as we receive the bail officer's reports, we continue to move even faster and faster with treating with the bail applications. But they are moving ahead steadily. You are hearing me refer to an office called the Chief Public Defenders. I want to remind you that this government birthed the Public Defender's Office. It is in operation as we speak. The Public Defender's Division has turned out to be a life savior for this country, because for the first time, people who don't have an attorney at law, those same people who are in prison right now, have the benefit of the state giving them a defense lawyer. And I would just like to remind you that so careful are we in the balance of justice that as Attorney General with responsibility for the legal aid authority, the person hired as the Chief Public Defender sat as a UNC senator twice in the last couple of years. So I'm just letting you know that there is no politics when it comes to carrying out function.
How soon will we be seeing the first release, though? I know the Mercy Committee needs to meet. So are we
first release
next
on
month?
Mercy Committee or from the courts considering bail? Which one?
Well, one is the courts regarding the marijuana.
Sure.
And the other one is the pandemic.
Well, we've already had releases from the courts. People have been granted bail. Bail applications have been heard and varied. People are out already, both for marijuana, both for the COVID prisoner situation. And the Mercy Committee is just simply awaiting the welfare officer's report to sit on the many matters. But we are well with people on the outside already.
And going back to the virtual courts, the cost of these courts and who was the contractor that built them and the outfitting of these courts?
Sure. What we did to get this thing done is that we used mobile courts. We took containers, shipping containers. We retrofitted the shipping containers at a cost of roughly $70,000 per shipping container. We now have 12 courts. I couldn't tell you who the contractor is right now. A lot of it was done in-house by the judiciary. But what I can tell you is, as at today's date, 1,450 matters have been heard directly from the prisons by way of virtual hearings. Let me repeat that. 1,450 matters. I want to remind you that the prisoner transportation cost to the taxpayers at its highest under the UNC used to be approximately, VAT inclusive and including the charges of NIPDEC, approximately $43 million per year. That figure under this government, thanks to the capacity that Amalgamated was able to give in constantly reforming itself, that figure dropped to $25 million and less per year. But now we are in a position where in a matter of short space of time, March 16th to May 13th, thanks to what we have done, 1,450 matters have already been heard in those virtual courts at the prisons.
AG, are you aware that there are some inmates who brought threatening legal action against the state regarding the COVID release?
Of course.
What is happening with that?
So I'm involved in every aspect of litigation, obviously. And let me put something on the record here. I noticed that there is a tendency to make some kind of allegation that this office holder of Attorney General has not been meeting with success in the courts. Every single case that has been brought against the government that has been managed by this office, in particular in the COVID pandemic, every single case has ended in a loss for the people that came before the court. For Mr. Ram Logan, for Mr. Ramdeen, for Mr. Devant Maraj, those three persons in particular, they have lost every single case. The matter that you're referring to right now is almost rendered academic because the COVID cases are moving with alacrity. They are already before Madam Justice Lisa Ramsumer Hines for bail application variations and for Mercy Committee. So we are well in control of those matters.
AG, a bit of clarification for members of the public who are a bit concerned by statements by some senior police officers who appear on television from time to time on social media in terms of the Dangerous Drugs Amendment Act that was passed in December last year, took effect on the 23rd. People are wondering, 4 plants per person or 4 plants per household?
The law is clear. It's 4 plants per person.
So if I have 4 adults in my house, I can have 16 plants. We all smokers.
I want to keep today's conference to the issue at hand, which is bail. I want to remind that the Trinidad and Tobago Police Service have very considerable powers at law, and I want to remind people that there are other articulating laws beyond the Dangerous Drugs Act, right? There are multiple laws that oscillate at the same time. So respectfully, let's just focus on the bail issue before we get a little bit on a tangent.
Okay, in terms of the bail issue again, in terms of you're taking away a person's liberty, we understand.
Well, we're not, huh?
We are in circumstances, but in terms of processing the case and securing the convictions, has any thought, has any money been allocated to help buffing up the forensic science center to speeding up in terms of the time frame of testing the weaponry, doing ballistic tests to facilitate faster trials?
Absolutely. I want to remind you about the pace of trial right now. So first of all, we are not taking away your right to bail. We have specifically included the fact that you always have the ability under Section 5, Section 5.1 and Section 5.7a to knock on the door of the court and show exceptional circumstances as to why you should get bail. That's a very big difference from what the other bail laws were, ending with the laws that collapsed in 2016. Under those laws, you could not knock on the door of the court. The court was pushed out. It's called an ouster. In terms of speeding up trials, that's why we did so much virtual hearings, criminal proceedings rules, forensic evidence, moving judges from 36 to 64 legislatively, moving masters from 2 to 25, opening by the time we finish the courts very shortly at the waterfront, approximately 125 new courts. So we have done a massive amount to move the pace of justice forward. We're now doing trials in 15 minutes. We've done murder trials by judge only. We have had a conviction by judge only for murder and an acquittal by judge only for murder. So Trinidad and Tobago's judicial system today is vastly different from what it was in 2015. And we will give account of that in the public in the course of the next couple of weeks in particular.
AG, sorry for hugging the mic. If no public outcry, what's the next step for the government?
You buy what you get. So the only people that have a chance of making a benefit here, the senators did their part, the independent senators did their part, the government did its part, the government has come forward asking for this law to be supported. The only people standing in the way of crushing crime seem to be the members of the opposition, because there is no other explanation for it. Because if it was good enough in a worse way of restricting bail under Mrs. Prasad-Bissessar, how come it's not good enough in a better way under this particular government? Are there any other questions? Jewel?
Just a follow-up on my colleague's question. So without the support of the opposition, from a legislative standpoint, institutional framework standpoint, what would then be the option for the government?
There is no legislative option other than passing the law. The police are out and about. They're in heavy numbers. They are arresting 2 people per day. They are finding the weapons of war. They're being released out on bail. The only effect that we saw this work well with twice was with kidnapping for ransom. You remember where this bail restriction came about? It was a PNM government that brought in 60-day no bail for kidnapping for ransom. The UNC took that to 120 days in 2011. That bail restriction crushed kidnapping for ransom. Remember when kidnapping for ransom was a big issue in this country? It was the bail restrictions passed in the parliament that crushed kidnapping for ransom. It was the bail restrictions that Minister of National Security Gary Griffith saw success with in locking up people with firearm matters. Commissioner of Police Gary Griffith is asking the population in a very strident way to pay attention to the fact that he knows it works. Because when he was minister, he had a prime minister, Kamla Prasad-Bissessar, who brought this law forward. You cannot watch a commissioner of police who sat as a minister of national security say what he said yesterday and not be deeply alarmed about your fate, about our fates.
Just one other question. As you deal with the legislative side of it, what about the issue of the firearms, illegal firearms, coming into Trinidad and Tobago? What's the update on the strategies to deal with that side of it?
I can tell you that we have had very great success on interdiction. Yesterday I had a conversation with the Department of Treasury of the United States of America. They scheduled a conference call with me. I spoke with my counterpart, the head of the Department of Treasury, and the Department of Treasury, in reaffirming Trinidad and Tobago's commitments and our successful relationship, was very, very happy. They stated it very positively at all that we are doing. Firearm interdiction, the management of our borders, our external relationships. I can confirm to you now that I held a telephone conference with the US Department of Treasury, and they were extremely pleased with Trinidad and Tobago in all of its affairs. We reflected upon the firearms matters and the drug busts that we had by way of joint operation, and our relationship with the United States government continues to be an excellent one, particularly as we relate to border control and management issues and fighting crime.
I think this would be my final question, hopefully. You just mentioned that bail restrictions stopped or more or less eradicated kidnappings. There was bail restrictions under the UNC for the 5 years, and there were still gun-related offenses. What assurances can you give that if the UNC were to come back to the table and agree to this, that we would see a decrease in gun-related offenses?
Because we've had an improvement in policing, because we've added 100 municipal police in the 14 corporations, because we've amended the criminal procedure in Trinidad and Tobago, because we have reduced the caseload inside of the courts. Look, on May 26th, folks, the magisterial caseload is about to dramatically drop, you know. Every year, the magistrates court has 146,000 matters. In December 2019, we took out 8,500, just marijuana matters alone. On May 26, the day after Eid ul-Fitr's public holiday, we go live with the U-turn system, ticket in the mail, demerit point system. 104,000 matters stop going to the magistrates court. When we abolish preliminary inquiries very shortly, as we're working out those details now, another 26,000 cases will fall off. That leaves only 8,500 cases per year in the magistrates court. So what we're saying is there has never been such a radical transformation of the justice system in this country. Let me ask you something. Have you ever heard an attorney general tell you that between March 16th in a particular year to May 13th in a particular year, 1,450 matters were done from the prisons themselves by way of a court hearing virtually held? These things are not average everyday news, you know. This is radical transformation of our country. And it is for that reason that the assurance can be given that at least the police will have a better fighting chance. We've never had a commissioner like Gary Griffith, in some senses, with that kind of zeal and that kind of energy and that kind of direction in leading the troops himself. I'm confident that if you allow the Trinidad and Tobago Police Service, which is an independent entity to operate, that it will do the job. And I reject Mrs. Prasad-Bisessa's statement that the police can frame people because of a government desire. That is nonsense. Because if that were the case, I asked Mrs. Prasad-Bisessa whether she is aware if she ever had her government frame anybody through the Trinidad and Tobago Police Service. The record shows that the Trinidad and Tobago Police Service have acted, including against persons who have held or do hold political office in this country on either side of the coin. Ladies and gentlemen, I thank you for your questions, and I do hope that you facilitate the public advocacy for the bail laws to be brought back to Parliament. Thank you very much.